so we're not, this isn't a class on Torah or specifically, but Ruth Bader Ginsburg, created a Torah that we study. So I think it does make sense in this context that we as a synagogue gathering, studying the works of this woman, start with the blessing that we offer when we engage in the acts of Torah. Baruch atah Adonai Eloheinu melech haolam, asher kiddushanu b'mitzvotav v'tzivanu la'asok b'divrei Torah. We are grateful to God for the gifts of Torah and enabling us to engage in it in so many ways. And Torah itself is obviously mostly a compilation of laws. And the wider understanding of Torah is the Bible, and there's a whole book named for a woman named Ruth, and that name has become. She was really she's one of the true heroes of the ancient world, and of course today we have another Ruth that we look to for her wisdom and all that she has done for this nation. And we are so lucky to have Leora Harpaz as one of our members. Professor Harpaz began her teaching career in Canada at Osgoode Hall Law School. And she was, I think, am I right, Leora, like Ruth? Ruth was in private practice for a little bit too, right? Before she.
No,
I'll let you tell her story.
I'll tell a little bit of her story. I mean, I have been given the task of talking about her legal career.
I know.
I'll try and stick to that for the most part, but I confess I've stuck in a number of biographical details because I can't resist.
Well, of course, that's
Right.
that's the fun stuff too.
Right.
So, but our Leora worked in private practice for a few years, and then she joined the faculty of the New England University Law School and
Western New England.
Sorry, Western New England.
Different school, New England. We're not allowed to make that.
I understand.
Okay.
I totally understand. We get very sensitive at Temple Shari Tefillah when people confuse us with Shari Tefillah in Westchester. So I get it.
Mm-hmm. Right.
We have to know what we're talking about. I'm going to actually let you, Leora, fill in some of the most recent places that you've been doing teaching, but also for everyone to just know that her writing and scholarship has particularly been in the area of First Amendment and the rights of public school students and the internet and all sorts of things that are deeply relevant to all of us in our lives and of concern. And when I came to know Leora was because she is a big fan of Ruth Bader Ginsburg. And when she heard that Rabbi Lenz and I were offering a multi-part session on RBG, she so generously provided me with a lot of her wisdom and insight and notes and resources. And so I asked her if she wouldn't mind just one day, taking on the educating directly, and she so graciously said yes. And for that, I am so happy. And instead of my talking anymore, I introduce you all, if you haven't met her yet, to Leora Harpaz. We're so glad to have you here tonight.
Thank you. I don't know that you need to hear more about my career because this is really about Ruth's career. I'll just say briefly that when I became an emeritus professor, my goal was to move back to New York City where I grew up. And I accomplished that. And since I've been here, I've done all kinds of things. I worked for the New York Civil Liberties Union. I taught at Hunter College. I've taught at a whole variety of senior learner programs in the city and a variety of other things that have cropped up. I do some work for the Posse Foundation. I don't know if anyone's heard of it. They give scholarships to mostly to low-income students for college. Anyway, I've definitely been busy since I've been here, although I have not yet spoken at a synagogue, I will say. Although I did in our synagogue at Springfield, I sometimes did sessions on some aspects of the law related to religion. Anyway, tonight I'm going to talk about Ruth Bader Ginsburg. She is, of course, as everyone knows, famous for her work developing constitutional protections against gender discrimination, both before she became a Supreme Court justice and after she joined the court. In addition, in many ways, her work and her personal life intersect in various ways. And as a result, it's really hard to tell the story of her work in one class. And I want to give everyone who wants to an opportunity to participate. So I've decided to divide her career into 5 acts and have kind of intermissions between the acts for discussion. And in the first act, I'm going to talk about her early involvement in the area of gender discrimination before she became a federal judge, and her earliest direct involvement with cases that involved sex discrimination began with work she did while she was volunteering for the New Jersey chapter of the American Civil Liberties Union while she was a faculty member at Rutgers Law School in Newark, New Jersey. And toward the end of her time at Rutgers, she worked with her husband, Marty, who was a prominent tax lawyer, on an early gender discrimination case called Moritz versus Commissioner of Internal Revenue. And for those of you who saw it, the Moritz case was the centerpiece of the movie On the Basis of Sex, with Felicity Jones as Ruth and Arnie Hammer as Marty Ginsburg. And the movie is, it turns out, a very accurate depiction of the Moritz case and the involvement of the Ginsburgs, undoubtedly because the screenplay was written by Ruth and Marty's nephew, Daniel Stiepelman. And Stiepelman has said that he got the idea for the screenplay of all places at his uncle's funeral. He died in 2010. When the Moritz case and Ruth and Marty's involvement in the case was described in one of the eulogies. And in addition to her nephews writing the screenplay, RBG herself was very involved and even read and commented on numbers of drafts of the script. So the Moritz case challenged a provision of the Internal Revenue Code that denied a deduction for the salary of a caretaker claimed by Charles Moritz. And he was a man who was caring for his elderly, dependent mother, but he was denied the deduction because he was male and because he had never been married. He protested the denial of the deduction, but the tax court rejected his petition in October of 1970. And it was at that point that Marty Ginsburg read about the case. He was a tax lawyer, he read about the case, and he helped to persuade Moritz that he should appeal the tax court's decision to the US Court of Appeals for the 10th Circuit and be represented in that appeal by both Ginsburgs. And after he agreed to allow them to represent him, Ruth contacted the ACLU, the national chapter, and they got involved in the case as well. She actually contacted the national legal director of the ACLU, who turns out to be a man at that time named Melvin Wolfe. And it turns out that Ginsburg had met Wolfe many years earlier when he worked as a waiter at a Jewish girls' camp where she was a camper. And at the time he was 16 and she was 12. And they basically had not been in touch during the past 26 years, but he was glad to get back in touch with her, and he agreed that the ACLU would participate in the Moritz case and help write the brief that was filed in the case presenting Moritz's legal arguments. The case was RBG's first oral argument before a court, and Marty and she divided up responsibilities. He took the tax issues in the case, and she argued the constitutional issues in the case, and which were equal protection issues. And they argued that Moritz, who was employed and unable to care for his mother himself without hiring someone to look after her, would have been eligible for the deduction if he was female and had never been married, and there was no rational reason for treating him differently under the Internal Revenue Code, just because he was male. And as a result, they claimed that the IRS regulation violated the Fifth Amendment equal protection guarantee. They also argued that the remedy in the case should be that the court should extend the deduction to men as well as women, rather than the alternative, which would be to strike it down as to everyone. And when the 10th Circuit, after some delay, finally issued its ruling in the case, which was in November '72, the Ginsburgs were successful in both of their arguments. The government filed a petition asking the Supreme Court to review the case, but its petition was denied. And at the time, the Solicitor General's office, representing the government in its unsuccessful effort to ask the Supreme Court to review the Moritz case, was headed by Erwin Griswold, who had coincidentally been the dean of Harvard Law School while Ruth and Marty were students there. So in addition to vindicating equality rights, I'm sure that the victory in the Moritz case was even sweeter because Ruth scored a win over Griswold, since Harvard Law School, when she was there, was not a very welcoming place for women students. There were only 9 women in her class and over 500 men. And numbers of the professors were reluctant to call on women students, even when they volunteered to speak, as Ruth often did. In addition, Harvard was unwilling to allow her to spend her final year at Columbia Law School in order to keep her family, in which included at that point her 3-year-old daughter, together after Marty graduated. He was the year ahead of her, and took a job at a law firm in New York. She could not get a Harvard degree and take her 3rd year elsewhere. So instead, she had to transfer to Columbia for her 3rd year, and she received a Columbia degree, something she really never forgot throughout her life, that this had happened. And nowadays, and for quite some time, the ability to visit at another law school and still get your degree from the place where you spent the first 2 years is commonplace. But in 1958, it was something that Harvard didn't allow. So one other important development on the subject of sex discrimination occurred while Moritz was being litigated. The Supreme Court decided a case called Reed versus Reed in 1971, and it struck down an Idaho law. And this law required that as between persons equally entitled to administer a decedent's estate, males must be preferred to females. And it was the first case in which the Supreme Court found gender discrimination to be a violation of the Equal Protection Clause, using the exact same argument, essentially, that the Ginsburgs had relied on in the Moritz case, that it wasn't rational to treat the 2 genders differently. So they made an argument in Moritz that there was no rational reason for the difference in treatment, and that was the basis also for the court's decision in Reed. While Ginsburg didn't argue Reed before the court, she did play an important role in the case because the ACLU joined Sally Reed's attorney in litigating the case. And the leadership of the ACLU had been so impressed with Ruth's work in the Moritz case that they asked her to work with Melvin Wolfe to write the ACLU's brief. So her representation of Charles Moritz led to the next chapter in Ginsburg's career, which I'll talk about next, but we've come to the end of the first act. And so if anybody has any reactions or comments or questions about this first part of the Ginsburg story, I'm happy to hear them now. If anyone wants to just kind of raise your hand if you have something to contribute. Okay, well, I don't see Miranda. Yes.
I was just going to say that I didn't know that story about the film and the writing of the film, and I saw the movie, so I'm glad to know that it was very accurate.
Yes, it was very accurate. I read that Ruth kind of objected to every small kind of liberty that they took with the movie, and her nephew had to convince her that some of the things were necessary. There's a famous scene at I think it's the end of the movie, where she walks up the stairs of the courthouse to the Supreme Court, and she's in high heels, so you can hear the clattering of the shoes. And she said to her nephew, "I would never wear heels. I would always wear flats." And he said, "Well, you know, Aunt Ruth, it's very important that, you know, you really notice that she's walking up the stairs, that you hear and she finally conceded that it was okay to take that liberty with the truth, but she was very fussy about the script in general. Anyway, the next act in her career involved her leaving Rutgers after the 71-72 academic year, right after her successful work in the Moritz and Reed cases. And that year, she joined the Columbia Law School faculty as a tenured professor. She was the first woman to be tenured at the law school, and she remained on the faculty until she became a judge in 1980. In her academic work at Columbia, she taught Columbia's first class on sex discrimination law, and she also co-authored the first law school casebook on sex discrimination. But her time at Columbia was important for another reason. At the same time as she would join the Columbia faculty, she was hired by the ACLU to co-found their Women's Rights Project. Under an arrangement worked out between the two employers, between Columbia and the ACLU, they each agreed to pay half of her salary, so she could kind of work half-time in each location. And the Women's Rights Project, of course, challenged laws that treated the sexes differently. And Ginsburg developed a step-by-step strategy to attack such laws, which was parallel to the one that was used by Thurgood Marshall to attack so-called separate but equal racial discrimination. And her strategy involved taking a number of cases, sometimes representing men, as she did in the Moritz case, and sometimes women. And the goal was to show that gender discrimination can disadvantage men as well as women. And to also show that the same law can often disadvantage both genders. While teaching at Columbia and working at the ACLU, first as the co-founder of the Women's Rights Project and later as one of their general counsels, she argued 6 sex discrimination cases before the United States Supreme Court, and she lost only 1. And she also supervised hundreds of other cases that were brought by the ACLU. Ginsburg did not have the objective of fighting sex discrimination when she decided to attend law school. When they were in college at Cornell together, she and Marty agreed that they would both choose the same career. So they would have that in common. And after discussing numbers of options, they decided it would be law. Well, from what I've read, it seems to me pretty clear that it was likely more Ruth's preference than Marty's, since he was a chemistry major and had not really considered law school as a possibility at all. Also, as I understand, he spent more time playing golf on the golf team when he was at Cornell than worrying about his academic studies. On the question of why law school, Ginsburg has admitted that she chose law school not because at the time she had any passion for social justice at all, but only, as she has said, for personal selfish reasons. I thought I could do a lawyer's job better than any other. I have no talent in the arts, but I do write fairly well and analyze problems clearly. It was kind of a self-assessment of her talents, and so law school it was. Returning to the 6 cases she argued, I'm going to group them by the kind of issue that was raised in the case, beginning with the cases that involved financial benefits. And I'll start with the first case that she argued before the court, a case called Frontiero versus Richardson in January '73. In an interview she gave to Elle magazine, she said, "I was very nervous. It was an afternoon argument. I didn't dare eat lunch. There were many butterflies in my stomach. I had a very well prepared opening sentence I had memorized. Looking at them, I thought, I'm talking to the most important court in the land, and they have to listen to me. And that's my captive audience. Then I felt a sense of empowerment because I knew so much more about the case, the issue, than they did." At the end, one of the more famous parts of this oral argument she gave came at the very end, where she quoted a 19th century abolitionist and activist for women's rights, a woman named Sarah Grimke. And at the end of the argument, she said, quoting Sarah Grimke, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks." So in this case, Sharon Frontiero was Ginsburg's client, and she was an Air Force lieutenant who applied for a dependence allowance for her husband, Joseph. And her request was denied because Joseph wasn't dependent on her for more than half of his support. By contrast, wives of members of the military automatically qualified for a dependence allowance without any need to show that they were actually financially dependent on their husbands to any extent at all. The court ruled 8-1 in favor of Frontiero, deciding that the husbands and wives of members of the military should be treated equally on the issue of qualifying for a dependence allowance. But a majority didn't adopt the argument that that gender should be considered a suspect classification like race, and the court should analyze gender discrimination with the same strict standard it used in race discrimination cases. Only 4 justices adopted that position, the one that Ruth advocated for, 1 vote short of declaring gender discrimination to be a suspect classification like race, something that has never happened ever since that time. 4 votes was as close as it ever got. In 1975, Ginsburg was in front of the court for the 4th time in the first of 2 challenges to provisions of the Social Security Act. The case was a case called Weinberger versus Weisenfeld, and she represented Stephen Weisenfeld. And Stephen's wife, Paula, was the principal wage earner in their family. Contributions to Social Security were, of course, deducted from her salary. In 1972, Paula died, giving birth to their first child, leaving Stephen to raise their newborn son alone. After her death, he applied for Social Security benefits for himself and his son. And his son was granted benefits as the minor child of a deceased worker. But Stephen was denied benefits since survivor benefits at that point were payable to the parent of a minor child, the surviving parent of a minor child, were only available to widows whose husbands had died and not to widowers. And Ginsburg successfully challenged the discrimination, arguing that the law discriminated against both men and women, since the law discriminated against men who were interested in caring for their children, as well as women workers whose Social Security taxes earned them fewer benefits than male workers. Years later, in 1998, this case was back in 1975, so many years later, Justice Ginsburg presided at the wedding of Jason Weisenfeld, the young son who had received the survivor's benefits. And 16 years after that, in 2014, she officiated when Stephen Weisenfeld remarried at the age of 71. And I read that she kept in touch with many of her former clients in this way, that she considered them to be, people in her lives ongoing and not just a client whose case was finished and that's the end of you. And so I'm not so surprised at the story about Jason and Stephen Weisenfeld. The next year, she argued a case called Califano versus Goldfarb, and it challenged another provision of the Social Security Act. It involved a widower who applied for survivor's benefits based on his deceased wife's 25-year work history. And he was denied the benefits because his wife didn't provide half of his support at the time of her death, similar in that way to Frontiero. There was a condition on men receiving these benefits unless their wives supported them to more than half. This same requirement was, of course, not imposed on widows who were automatically eligible for survivor's benefits. And the court struck down the requirement, and it relied on its previous decisions in Frontiero and Weisenfeld, and agreed with Ginsburg that the law disadvantaged both males and females. So you can see her developing this line of cases as she carefully picked cases to present to the court. Before reaching the next of her cases, I'm going to talk about another case, a case called Craig versus Boren, which was argued the same day as Califano versus Goldfarb. And it was the case in which the Supreme Court adopted a stricter standard to review gender discrimination under the Equal Protection Clause. And the court didn't adopt the same standard that applies to racial discrimination, which was the test advocated by Ginsburg and Frontiero, but it didn't continue to use the very deferential rationality standard that it had been using. It compromised on an intermediate test that was fairly rigorous. And while Ginsburg did not argue the case, she did, of course, play an important role. She filed a friend of the court brief on behalf of the ACLU, and she, I'll just describe it as indirectly participated in the oral argument. In one of these many coincidences that her life seemed to be full of, her oral argument in Califano was in the afternoon of October 5th in 1977. And Craig had already been argued that same morning. And what happened was, during the oral argument in Goldfarb, Justice Stevens asked her a question about the discrimination in Craig, fairly unusually, which involved a law, a very different law that allowed underage women, but not men, to buy a type of low alcohol beer. So the victims of the discrimination were principally men. And Stevens asked her whether the law only discriminated against men or whether it discriminated against both men and women. And what she answered was that the paternalism that justified the enactment of the law discriminated against both genders. And why did Stevens pose that question? I think because at that time the issue was unresolved in these early gender cases, whether if discrimination based on gender was analyzed using a more rigorous test than the court had been using, whether that test should apply no matter which sex was disadvantaged, or whether the rationality standard should apply if only men were disadvantaged. And in Craig, the court adopted a more rigorous standard, and they also applied it to all instances of gender discrimination, no matter which gender was harmed. And as a result, they struck down the alcohol restriction. In this line of cases, Ginsburg only lost once. The court ruled against her client in another case involving financial benefits, and it was Kahn versus Shevin in 1974. And her client was a man named Mel Kahn, a Florida resident whose wife had died. These cases seem to be full of dead wives, I must say. But in any event, the case involved a $500 property tax exemption that the state of Florida gave to widows, but not to widowers. And when the tax assessor denied Kahn the exemption, he filed a lawsuit. The Florida Supreme Court ruled against him on the ground that the law was a reasonable effort to remedy some of the financial hardships that were specifically faced by widows, more so than widowers, and the Supreme Court agreed. And it distinguished Frontiero from Kahn versus Shevin on the ground that the government's justification in Frontiero for the discrimination that it was practicing was just that it was more administratively convenient to have that rule, that 50% dependency rule, more than 50% dependency rule. Whereas in Kahn, the government relied on the fact that the quite modest $500 additional property tax exemption was to compensate widows for the greater financial difficulties that they generally faced on the loss of a spouse as compared to men who became widowers. The remaining two cases in her career had to do with jury service. And the first was neither a victory nor a defeat because the court never did decide the case because in the interim, Louisiana changed the law that allowed women to not to serve on civil juries unless they specifically filed a written declaration that they wanted to serve on a jury. Otherwise, they didn't have to. And when the case was being litigated, Louisiana changed its law, so the court never reached a decision on the merits. They sent the case back to the lower court to be reconsidered in light of the change in the law. The other case was in 1978. It was her last case in which she argued before the court, and the court allowed women upon the state allowed women upon a request an automatic exemption from jury service. And the court decided that that violated the Sixth Amendment right to a jury trial. And the jury had to be chosen from a fair cross-section of the community, and basically allowing all women not to participate in the jury denied the defendant that cross-section. So I'm gonna kind of pause here for any questions or comments about this line of cases, but you should think of it more as a scene change than the end of Act 2. I see Marion's hand is up.
Yeah, I'm curious. Do you think that she deliberately picked cases where men were discriminated against, thinking that male judges would be more sympathetic?
Wouldn't surprise me at all. But I also think that, I mean, this is sort of similar to what you're saying, but a slightly different way of framing it. I think that she thought that maybe the judges thought that the only real victims of sex discrimination were women. And that wasn't nearly as relevant to them as the fact, as if the victims were men, and she was proving to them, hey, you think, guys, that this doesn't, all the 9 male justices on the court, you think that this doesn't affect you too, but it does. And I'm going to show you that in this group of cases that I'm bringing before the court. So I think, maybe it's that that it's easier to worry about discrimination if you think it could apply to you than if it applies to the other.
Hi, it's Jill Franco, and sorry I can't raise my hand because I'm driving, and
Yes.
I'm ironically through the middle of the Cornell campus as I say this. So perhaps paying homage to her. But I think as you were describing these cases, and thank you for doing so in such an excellent manner that we can all digest all the details. One thing that struck me is not only, you know, the legal aspect and the outcome of the case and this issue that the men were the plaintiffs, but it really was, for me, the way you were describing them made me realize that it's a very interesting look at the way we see gender and the roles of gender, and you know, these cases that on their surface are about, you know, support and taxes and, you know, whatever economic issues, you know, saying who can be a breadwinner, who needs support. These are all ideas that there were set ideas about gender. So even though the plaintiff was a man, I think it forced, you know, not just the justices, but people to start thinking maybe about roles of gender differently.
Yes, and this was a time when I think there was, you know, the beginning of a change in gender roles. And so it kind of coincided exactly with the point you're making. People were beginning to reassess. Women were entering the workforce in much greater numbers. And so I do think that the country had, that these cases may have helped the country kind of awaken to the fact that these traditional roles weren't always going to be the way that they had been. So here I've taken a little, I guess I should say, dramatic license because before I move on to her career as a judge, I wanted to talk about her own personal experiences with gender discrimination, which undoubtedly contributed to her choice of gender discrimination as an area of specialization, as well as making her victories in these cases even more meaningful to her. And one early example is that after her mother's death from cancer, right before Ruth graduated from high school, in keeping with Jewish custom at the time, Ruth wasn't allowed to say the mourner's Kaddish for her mother as part of a minyan because, as you know, at that time, only men could participate. And her exclusion from that ritual to honor her mother had a lasting impact on her relationship with the Jewish religion. And according to Jane DeHart, who wrote a biography about Ginsburg, she wrote, "She was extremely indignant about it. She felt it was an affront to her mother and there was nothing she could do about it. That was largely the end of her affiliation with the religious dimension of Judaism," which I think towards the end of her life, she kind of re-embraced to a certain extent. Next came her first experience with workplace discrimination. After she graduated from Cornell and almost immediately married Marty, a very traditional thing to do at that time, he was called for active duty, and they moved to Oklahoma for his military service, and where Ruth got a job working for the Social Security Administration. When she became pregnant with her daughter Jane, she was told that she would receive no more pay raises or promotions because she was having a child. She next experienced other forms of discrimination while she was a student at Harvard Law School, in one of the first classes to admit women, when in many ways the school hadn't really adjusted to coeducation. When she testified before the Senate Judiciary Committee after she was nominated to be on the Supreme Court, she actually told the committee that her experience as a student at Harvard was a major reason why she spent her career fighting sex discrimination. Next came her difficulty getting a job after graduating from Columbia, where she was tied for first in her class and also an editor of the Law Review. But being a woman, a mother, and a Jew resulted in her receiving no offers at all from New York City law firms. Instead, it was thanks to a professor of hers at Columbia, a man named Gerald Gunther, who was also a noted expert in constitutional law, that she got her first job. She was hired as a law clerk for U.S. District Court Judge Edmund Palmieri. And only later did she learn that getting the job involved Gunther threatening to never recommend another Columbia student to the judge if he didn't hire Ginsburg. And so Ginsburg was hired. But I guess he must have liked her a lot, because because the traditional length of service in a clerkship like that is 1 year, and he kept her on for a second year. The next significant part of her career involved becoming a law professor and getting directly involved in women's rights legal issues, but she experienced discrimination even in that setting. When she was hired by Rutgers Law School in 1963, she was one of only 20 female law professors in the United States, and she was the second woman on the Rutgers Law School faculty. And when she was hired, she was informed she would be paid less than her male colleagues because her husband made a good salary. She later joined an equal pay campaign with other women faculty at the university wide, at Rutgers University in general, not just the law school, and they were successful in achieving pay equity. In addition, before she received tenure, this was during the spring '65 semester, she became pregnant with her second child, her son James. And I think undoubtedly remembering her experience in Oklahoma getting pregnant and what happened on the job, she wore loose clothing to hide her pregnancy, which she didn't announce until the semester ended, and she was already 6 months pregnant. Her years at Rutgers were also quite important to her future work for other reasons as well. She was hired to teach civil procedure, where she had a lot of expertise, but at a certain point, she was asked by a group of women students to teach a class on women at the law, which Rutgers did not have at that time. And to prepare, not surprisingly, she read every single thing about the subject that had been written. And she discovered that there was actually very little out there. And she then received tenure in '69, and the next year she became the faculty advisor to a journal started by Rutgers students called the Women's Rights Law Reporter, which was the first US law journal to specialize in women's rights. In addition, as the number of women that coming forward complaining about discrimination increased, she volunteered to work on gender discriminations for the New Jersey chapter of the ACLU, which ultimately led her to her work heading the Women's Rights Project. Anyone like to comment about her personal experiences with discrimination and whether you can identify with what she experienced at all? Yeah.
I just remember that even as an intern, I became pregnant the first time when I was a rabbinic intern. So I was a student and only worked at the synagogue part-time and was so nervous at how my pregnancy would be received and how it was going to disrupt my work and what was everyone going to think. And, and I look back now and I think, how could I, what was I so worried about? But the environment and I don't know, I think we live, the environment leads us to believe that, that the women's lives, women's bodies, women's experiences are sort of the exception rather than the rule, or, you know what I mean? Which doesn't make any sense either, since we're 51% of the population. But so anyway, that just when you talked about it and how she wore these loose clothes, it just resonated for me that's, I'm a generation or so later than her, and I was still having those worries. And I hope that my kids, should they choose to become pregnant, don't have that experience as well.
Yeah, I mean, I can relate as well. I came along into teaching. My first kind of permanent teaching job, where I was going to be considered for tenure after a certain number of years, was in the fall of 1976. So some years later, but still at an early point in the hiring of women. For a time, I was the only woman on the law school faculty. And I later learned that I was actually being paid less than male colleagues who were hired at exactly the same time as I was. And in general, I would say that you even felt it from the students, that they were always testing you, in those early days. Does she know as much as our male professors? If we try and, ask hard questions, will she wilt, or what in a way that male professors were never tested. I mean, if a woman was tough in the classroom, she was a bitch. If a man was tough in the classroom, he was able to control the class effectively. And it was really like that. I'm sure she experienced some of that as well in her teaching career. Yeah, Len. Unmute yourself.
Oh,
I just did.
I recall that Elizabeth Warren went to Rutgers Law School.
Yes, they did not overlap. I once years ago looked into that question, and Elizabeth Warren was entering as Ruth was leaving. I mean, so there wasn't really an overlap although they came to know each other for various reasons, and so but they were not actually at the school at the same time. Yeah. Okay, so the next phase of her career, the next act, she becomes a judge. And in 1980, President Carter nominated Ginsburg to serve on the U.S. Court of Appeals for the District of Columbia, and she served there for 13 years. It was on the DC circuit that she developed her very close friendship with Antonin Scalia over their shared love of opera. And the two families became very close, with Marty, the primary cook in the Ginsburg household, and Maureen Scalia often cooking dinner for the two couples, who both lived in the Watergate complex. In speaking about her parents' different skills, their daughter Jane, who's actually now a law professor at Columbia, once commented about the assignment of responsibilities in her family. And what she said was, when she was growing up, mommy does the thinking and daddy does the cooking. And after Marty Ginsburg died in 2010, the wives of the other justices published a cookbook of his recipes in his honor, and the cookbook is called Chef Supreme. In September 1986, which was 6 years after Ginsburg joined the DC Circuit, Scalia became a Supreme Court justice. And one of Marty's goals became to see Ruth appointed to the court as well. And once Justice White announced his retirement in 1993, Marty began campaigning to secure her nomination for the court vacancy. So during her years on the DC Circuit, Ginsburg was viewed as a moderate and an incrementalist. On a court that was sharply divided between liberals and conservatives, she was one of the few judges in the middle, and she had good relationships with the judges to the right and the judges to the left. it was actually that reputation she had as a moderate and not as a crusader for women's rights that helped to persuade President Clinton to nominate her to the Supreme Court. She was the first nominee by a Democratic president in 26 years. The Democrats have been exceedingly unlucky in the timing of Supreme Court vacancies over the years. And at the time of her nomination, being a moderate made her actually acceptable to both Democrats and Republicans. And as we know, boy, have times changed. And Clinton wanted a moderate because he didn't want to spend his limited political capital at the start of his presidency trying to appoint someone more liberal, because he needed congressional approval for his legislative agenda. And because of her reputation as a moderate, she was actually opposed by some women's groups. There's a tradition when a nominee is announced, that the candidate makes some remarks, that the nominee makes some remarks. And in her remarks, when she was nominated, standing next to the president, she spoke about her daughter and her mother. And she said, she quoted from her daughter's 1973 high school yearbook, which said that Jane Ginsburg's ambition was to see her mother appointed to the Supreme Court. And then the yearbook adds, if necessary, Jane will appoint her. And she ended her remarks by talking about her mother, Celia Bader. And she said, I pray that I may be all that she would have been had she lived in an age when women could aspire and achieve, and daughters are cherished as much as sons. In her confirmation hearing, among other things, she talked about her husband and her great good fortune in finding a life partner, and how extraordinary her husband was for a man of his generation, because he believed that a woman's work was just as important as a man's. She was confirmed by a vote of 96-3, unheard of today. And she became the second woman on the court and the first Jewish woman to serve on the court. In her 27 years on the Supreme Court, there's general agreement that the most important decision, majority opinion that she wrote, was in United States versus Virginia, the case that struck down the male-only admissions policy of the Virginia Military Institute. And she wrote the opinion in 1996, which was only 3 years after she joined the court. It was joined by 5 members of the court. The Chief Justice agreed with the outcome in the case, but he didn't agree with her reasoning, so he didn't join her opinion. There was only a single dissent by her good friend, Justice Scalia. Thomas did not participate in the case because at the time his son was a student at VMI, and there was an obvious conflict of interest. I distributed, I think some people may have gotten a very heavily edited version of the decision, which I hope at least a few of you have read, at least in part. Before the VMI case, a number of things had already been established when it came to gender discrimination. So she wasn't writing on a blank slate. It was already established that the test that the courts would be using to decide if a particular instance of gender discrimination by the government was constitutional or not, and that was the intermediate scrutiny test. And that test is rigorous, but it's not the most rigorous test. Although the burden is on the government to show it can satisfy the test. And it asks, as is true in generally in equal protection analysis, whether the use of the gender classification by the government is substantially related to an important governmental objective. And that test applies whether it's men or women who are disadvantaged by the discrimination. And both of those things had been established back in Craig versus Boren in '76. In addition, the VMI case was not the first case decided by the court that involved a school of higher education that didn't admit both men and women. The first case was Mississippi College for Women versus Hogan, which had been decided in '82. And it was a case that involved a school of nursing that only admitted women and not men. So once again, a case involving just gender discrimination where the men are discriminated against. And the case struck down the exclusion of men in an opinion written by Justice O'Connor, the first woman on the Supreme Court. And her opinion was the first to describe the government under the intermediate scrutiny test as needing what's described as an exceedingly persuasive justification to justify gender discrimination. And that decision is actually quoted by Ginsburg in her VMI opinion. In the Mississippi College for Women case, the school's justification was that it was compensating women for past discrimination. And the court rejected that argument because the government hadn't shown that women didn't have opportunities to become nurses. And according to Justice O'Connor's opinion, by excluding men, the admissions policy was simply perpetuating a stereotype, the stereotype that nursing was a profession for women and not men. One interesting piece of information before I talk about the specifics of the VMI case is there's a book, a 2019 book about Ginsburg's career written by Victoria Ortiz. And she tells a story that I had never heard before. She reports that the assignment to write the VMI opinion was originally given to Justice O'Connor by Chief Justice Rehnquist, because one of the chief's jobs is when he is voting with the majority, he gets to assign the author of the majority opinion. However, he assigned, and as I say, he assigned that opinion to Justice O'Connor, probably because she had also already written the Mississippi College for Women decision. And so this was, simply a continuation of that line. But apparently, according to Ortiz, Justice O'Connor recognized that the area of law was, as Ortiz describes it, as near and dear, as Justice O'Connor saying, it was near and dear to her sister Justice's heart. And therefore, it was appropriate that she be given the assignment of writing the opinion, given all her work litigating gender discrimination cases. And she said, O'Connor said, this should be Ruth's. And O'Connor gave the assignment to her colleague, according to Ortiz. Now, one aspect of that just can't possibly be true. There's got to be a missing piece to that story, which has to involve O'Connor getting Rehnquist's consent to the reassignment. She couldn't just turn it over to another justice in that fashion. But aside from that, it's possible that's what happened, but I haven't seen any other source that confirms that story. So in VMI, after they had lost in the Court of Appeals, they had three choices available to remedy the equal protection violation. They could have admitted women. They could have stopped taking state money and become a private school, in which case the Constitution provision wouldn't have applied to their behavior. Or they could have created an equal program for women. The interesting thing about that is that tells you that even though separate but equal is not constitutionally acceptable when it comes to racial discrimination, the fact that a equal program would have been a cure tells you that separate but equal still lives when it comes to gender discrimination. What they did was they chose the last option, the creation of a separate but equal program, or what they argued was an equal program. And that was to create something called the Virginia Women's Institute for Leadership, VWIL, at Mary Baldwin College, which the lower court ruled cured the constitutional defect and therefore avoided admitting women to VMI. There were two issues that the Supreme Court had to resolve in reviewing the lower court decision: whether the admissions policy in the first instance violated the Equal Protection Clause, and whether, if it did, the remedy of creating VWIL was sufficient to cure the violation. I'm going to discuss the opinion, and I'm going to occasionally ask questions because I did distribute the opinion as if this were a law school class. But unlike in a law school class, I'm not going to force you to answer the questions. If nobody answers them, I'm going to answer them myself. So I'm going to start with the state's justifications under the intermediate scrutiny test. Virginia had to have at least one important justification for excluding women, and it offered two. Does anyone have any recollection about what the two justifications they offered were?
Leora, unfortunately, I don't think that document got distributed.
Okay. Well,
I'm sorry.
All right, no problem. Luckily, I know the answers to the questions, so I can answer them myself. So they argued that the program provided, the VMI all-male program provided educational diversity by having an educational program for men. And their other argument was that it was necessary to preserve the form of education used at VMI, which is described as adversative training, an adversative program of education. An adversative program sounds like something I would absolutely never want to study at. So here's a description. It features physical rigor, mental stress, absolute equality of treatment, absence of privacy, minute regulation of behavior, and indoctrination in desirable values. Cadets live in Spartan barracks where surveillance is constant and privacy non-existent. They wear uniforms, eat together in the mess hall, and regularly participate in drills. Entering students are incessantly exposed to the rat line, comparable to Marine Corps boot camp. Tormenting and punishing, the rat line bonds new cadets to their fellow sufferers, and when they have completed the experience, to their former tormentors. So that's the court's description of this version of education, this so-called adversative training. And the Supreme Court found that neither of these justifications qualified as an important justification. It rejected the educational diversity rationale because the state only offered a single program for men. In order for that to be a convincing argument, it would have been necessary for the state to have three educational programs: an all-male program, an all-female program, and a co-ed program. That would have created educational diversity, but not what Virginia had done. On preserving the adversative program, VMI argued if it was forced to admit women, it would have to make major changes in the program and denied men the full benefits of adversative training. That argument was rejected in Ginsburg's opinion as well, not surprisingly. And she wrote that that kind of response always occurs when an excluded class seeks to be included. And she said specifically, the notion that admission of women would downgrade VMI stature, destroy the adversative system, and with it, even the school, is a judgment hardly proved, a prediction hardly different from other self-fulfilling prophecies once routinely used to deny rights or opportunities. When women first sought admission to the bar and access to legal education, concerns of the same order were expressed. medical faculty similarly resisted men and women as partners in the study of medicine. Women's successful entry into the federal military academies, which had already happened, and their participation in the nation's military forces indicate that Virginia's fears for the future of VMI may not be solidly grounded. The state's justification for excluding all women from citizen soldier training, for which some are qualified, cannot rank as exceedingly persuasive. And while VMI argued that their program would have to be completely changed to accommodate women, the opinion doesn't accept that conclusion. It concedes there'd have to be some changes. Housing arrangements would have to be changed because there would now be 2 genders at the school. There'd have to be some security provided because we now had 2 genders occupying the dorms. And there would have to be some alteration in some of the physical standards that were necessary to successfully complete this form of training. But she concluded there wouldn't have to be changes to the basic aspects of the program. The opinion never has to reach the question of whether the use of the classification is substantially related to the achievement of important objectives, because Virginia failed to show that they had any important objectives to justify their refusal to admit women. And the court next has to therefore address this question of whether VMI has remedied the discrimination by creating the Virginia Military Institute for Leadership. And the answer was that it wasn't equal to VMI. It wasn't equal in any way, shape, or form. It wasn't equal in the form of education it offered, which was a cooperative method of learning and not adversative. It wasn't equal in the housing arrangements. There was no single dormitory for students in this program. They didn't even have to live on campus. And virtually every other aspect of the program, as well as the status of the school offering the program. The average standardized test scores for students at VMI were higher than those at Mary Baldwin College. The faculty members had many more PhDs per capita than was true at Mary Baldwin College. These are, it's funny, these are not so surprising. These are factors which the court used in a series of cases that Thurgood Marshall brought to the court to prove that certain kinds of separate education were not equal. He did a series of cases in which he slowly showed there wasn't true equality. And some of the criteria was the school wasn't as good. They didn't have as many supportive alumni, et cetera, et cetera, et cetera. And the court, in her opinion, she did exactly the same thing. I don't know if before I talk about another opinion, if anyone has any comments they want to make about the VMI case. Yeah.
This is really about Ruth Bader Ginsburg. I was just surprised to hear that Thomas recused himself. He hasn't recused himself from many cases. So.
Well, I mean, recusal in this particular circumstance, his son is a student at exactly the program now, currently, not 10 years ago or anything, currently at the very school whose educational system is being challenged as unconstitutional. I mean, you don't get more of a conflict of interest really in the standard scheme of things than that kind of arrangement. And everybody knew it. Everybody knew that his son, went to VMI. And so I'm not really surprised that is the case, that he recused himself. It was a fairly, standard reason for recusal. It doesn't happen very much, but it certainly fits within the, within the category.
I'm just surprised because he doesn't seem to see a conflict when his wife is involved in cases that have come before him more recently.
Well, I think it's sort of interesting because if you're a feminist, you might say, I'm not saying you're not, but some feminists might say that kind of holding the husband responsible for the behavior of his wife or vice versa is not really fair, that they aren't two independent adults responsible for their own activities. And, therefore, this actually came up with Chief Justice Roberts, interestingly. His wife is also an attorney. And also, she has been for instance, anti-abortion activist, or at least involved in organizations that oppose abortion in the past. And there have been questions raised about whether he should have participated in some cases raising issues where she has been at least active, not quite as active as Ginny Thomas, but active. And he never recused himself in those cases. I think it's a very, tough line to draw. It isn't as though, it's one thing, and a lot of reasons for recusal is when a family member is representing one of the parties before the court, or their law firm is representing one of the parties. But these cases about the kind of private non-work behavior of a spouse, I think are a little tricky. But you know what, it wouldn't have mattered at all in that case because Thomas was the only dissenter. So he could, if he had recused himself, it would have been 8-0. As it was 8-1. So it didn't really matter. Maybe he knew that. Who knows? In terms of other important majority opinions, she's really best known for her dissenting opinions and not her other majority opinions. There's one that I think is fairly important, other than the VMI case, which was the case involving a challenge to the constitutionality of the Arizona Independent Redistricting Commission, which was decided in 2015. And this was another 5-4 decision with Ginsburg's majority writing for the majority. And the dissents, there were 3 dissents. One was written by Chief Justice Roberts, another was written by Scalia, and a third by Thomas. The case raised the issue of whether the creation of this independent redistricting commission by voter approval of a ballot initiative, that's how it came into being, and it was designed to eliminate partisan politics from the redistricting process, from the congressional redistricting process, something we know a lot about today. And the argument was that the use of this commission violated a provision in the Constitution, Article 1, Section 4, the Elections Clause. And the critical language was the times, places, and manner of holding elections for representatives shall be prescribed in each state by the legislature thereof. And this case was really about what does that language, the legislature, mean? In her opinion, Ginsburg dealt with the issue of whether the redistricting commission took away power from the state legislature and therefore violated the Constitution. She denied that that was the case. And unlike the Chief Justice who, in his dissent, who interpreted the term the legislature as only referring to a representative body and not to other members of other methods of lawmaking. But Ginsburg and her majority disagreed with that. And what she said about this arrangement was Arizona voters sought to restore the core principle that voters should choose their representatives, not the other way around. The Elections Clause, we affirm, does not hinder that endeavor. And in her view, when the Constitution uses the language of the legislature, they really mean it to be a reference to all of the forms of lawmaking that the state permits, including provisions in the state constitution that allow for direct democracy through initiatives and referendums. I will say that that's a precedent that may be in jeopardy because a number of the justices on the current court have expressed an interest in considering what's now called the independent state legislature doctrine, which would be an interpretation of the elections clause that gives power only to the state legislature and not to any other form of state lawmaking. I'm going to kind of in the next piece of this talk about her attitude about abortion. But if there are any questions or comments before about her majority opinion. Okay, so let me get to abortion, much in the public eye today. And it does seem an appropriate topic in light of the leak of Alito's draft opinion in Dobbs, which of course overturned Casey, Planned Parenthood versus Casey and Roe versus Wade, and eliminated completely a woman's right to, or will be eliminating once it's a final opinion, eliminating a woman's right to terminate her pregnancy from the category of fundamental liberties. By the time Ginsburg joined the court, Roe and Casey had been decided, Roe 20 years earlier, but Casey only a year before. And Ginsburg believed that instead of protecting the right to terminate a pregnancy exclusively under the Due Process Clause, that it should actually be protected under the Equal Protection Clause as well. Because restrictions on abortion she viewed as discrimination against women. And legislation that sought to control the decisions made by women about when and whether to procreate violated their right to equal treatment and treated them like second-class citizens. It was a view that she actually had expressed at length when she was questioned during the Senate Judiciary Committee hearings when she was nominated by this to the Supreme Court. And she was asked questions about this, about her new view, which was known. And she talked at great length about a case that she had been litigating before Roe, in which she was presenting this kind of argument on behalf of a woman who was an Air Force captain serving as a nurse in Vietnam. And after she got pregnant, the Air Force, she could only have remained in the military if she had an abortion, which apparently in those days she could have gotten at a base hospital. The Air Force had a rule that women serving on active duty could neither be pregnant nor give birth. So their only recourse was an abortion. And the woman she represented was a devout Catholic, and she wanted to give birth to the child and then give it up to adoption and not terminate the pregnancy. And that case was on its way to the US Supreme Court when the military changed its policy. Therefore, the case was dismissed from the court's docket. It would have been decided before Roe, and it would have, had this not happened, and it would have meant that the court could have seen this issue in a slightly different light, a woman's choice, to control her reproductive destiny, rather than it being only an issue about abortion that the woman wants to have, but the government doesn't want her to. This is the flip of that. It was a very interesting case. And also Ginsburg was able to argue in the case that it discriminated against women because a male member of the military was not discharged if he had been a partner in the conception of a child, or because he was about to become a father. He got to remain, the woman did not. But the case was dismissed and the court decided Roe versus Wade the next year. Ginsburg not only thought that that abortion should also have an equal protection component to it, she also disagreed with the decision because she thought the court used the wrong approach. She agreed that they should have struck down the Texas abortion law, but she thought that the court was wrong in writing such a sweeping decision protecting the right throughout the pregnancy and detailing the way in which the legislature could regulate abortion at every single stage in the pregnancy. That level of detail was certainly unnecessary to a decision striking down the Texas law, because it prohibited all abortions throughout the pregnancy except to save the life of the mother. Instead, she thought the court should have only gone far enough in recognizing this right to strike down the extreme Texas law, but not gone any further. And she thought that judicial change in this area should have come more slowly to avoid interference with the liberalization of abortion laws, which had already begun in the states and was likely to have continued were it not for Roe. Roe ended that movement and, of course, as we know, galvanized the anti-abortion activists. And before she became a justice, she gave a speech at NYU Law School expressing this particular view. And she said about this, doctrinal limbs too swiftly shaped, experience teaches, may prove unstable. The most prominent example in recent decades is Roe versus Wade, a less encompassing Roe, one that merely struck down the extreme Texas law and went no further on that day, might have served to reduce rather than to fuel controversy. So any thoughts about her view, about her very different view about abortion than the kind of polarized circumstance in which the country has lived in all the years since Roe? Okay, so yeah.
I'll comment. I mean, if the moment we're living in now and present doesn't speak to her perspective, I don't know what does.
I mean, yes, I think, and she really predicted, the possibility that something like this could happen in effect by imagining, what the impact of a decision like this would be, that it would stop the pro-choice movement in its tracks. It had won, no reason to fight any longer, and it would have an enormous backlash on the other side, which is exactly what happened and led to our current circumstance. Yeah, I mean, I think there's a good argument that, her view was that the court and the legislature kind of would work in tandem, reacting to each other. Every small step and then a new law, and then another court case taking another small step and then a new law, back and forth and back and forth. And that would have allowed the country to kind of catch up with the way in which the law was changing. So,
Fascinating.
yeah. The other thing I'll just talk about very briefly, because we're coming to the end, is her dissenting opinions. She is best known for her dissents. In fact, some people have referred to her as the Great Dissenter, which is a title originally given to Justice John Marshall Harlan, who served from 1877 to 1911, and wrote powerful dissenting opinions. And she, one of her most frequently quoted dissents is in a case called Shelby County versus Holder in 2013. It's a case in which the court invalidated a key provision of the Voting Rights Act, which outlaws racial discrimination in voting through a mechanism that Congress enacted to identify jurisdictions that had a history of racial discrimination in voting and require that they get federal approval in advance for any changes that they want to make to their voting laws. And that was a process called pre-clearance. The court in this case, in the Shelby County case, invalidated the formula that was being used, had been used for many years to identify these jurisdictions that were subject to pre-clearance. Therefore, it eliminated any use of the pre-clearance process. And in her dissenting opinion on that point, what Ginsburg said about this was, the court strikes Section 4B's coverage provision because in its view, the provision is not based on current conditions. It discounts, however, that one such condition was the preclearance remedy in place in the covered jurisdictions, a remedy Congress designed both to catch discrimination before it causes harm and to guard against return to old ways. Volumes of evidence supported Congress's determination that the prospect of retrogression was real. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. And that dissent and the umbrella simile that you used helped to gain Ginsburg a following in popular culture and the name the notorious RBG. And of course, in addition, her view that it was preclearance that had prevented a return to discriminatory changes in voting practices has been proven true. That after the court invalidated the formula and prevented the use of preclearance, the states that had been subject to preclearance altered their voting laws in ways that adversely impacted minority voters, and that trend has become even more pronounced recently. It wasn't the first time that she dissented in a case involving voting rights. She actually also dissented in Bush versus Gore, the 2007 case, which secured the presidency for George W. Bush. And she disagreed with the court's, the way in which the court treated Florida law, because her view was that it wasn't the court's job to interpret Florida law. That was the job of the Florida courts, not the Supreme Court. And they should defer to state high courts when it comes to issues of the interpretation of state law. And that the court had not been mindful of our what's called dual system of sovereignty, with the states sovereign in their in the area of their own law, unless it's challenged on constitutional grounds, which this was not, and not otherwise. So she also dissented in a whole bunch of religious liberty cases where the accommodation of religious beliefs imposed a burden on others, which wasn't remedied. And there are a series of cases where the burden was imposed on women employees, and she dissented in all of those cases. Her last opinion before her death was, in fact, in one of those opinions, and she strongly disagreed with what the court had done. She actually said in a talk she gave at Michigan Law School in 2015 that she'd like to think most of her dissents will be law someday, but that day is certainly far off. So I think we've come pretty much to the end. If anybody, has something to say, I'm sure that we won't be evicted from Zoom for that reason, but anything
Are there any questions? And also, I'm assuming, Leora, that if anything occurs to people, they can let me know and I can connect them with you.
Just look me up, just type my name into Google. You're bound to find my email address 5 different places. And besides which, all it is my first initial last name at firstininitiallastname.com. Pretty easy. So they can write directly or they can write to you, obviously.
Great. All right. Well, thank you so much. I've been getting messages throughout by people who have just said how wonderful this has been. And I'll just say that, I know there are some people here who have a background, who are lawyers themselves or have a background in the law. I'm not one of them, and you have a great way of taking the complex and making it digestible for the rest of us. So thank you so much. I hope everyone has a good night. And really, Leora, thank you so much. You obviously put so much time in addition to just your enormous wealth of knowledge. We're grateful to you.
Thank
Okay.
you.
Thank you.
Bye-bye.
Bye, everyone.
Good night, everybody.
Thank you. Thank you.